Finally, the latest development at the federal level relates to severance agreements, which I just brought up in the context of the WARN requirements. WARN doesn't require that employees receive severance offers, but whether in that scenario or in any other scenario where an employer is trying to provide an employee some form of severance conditioned on usually waiving certain rights, the National Labor Relations Board at the federal level, which only affects private employers, but does affect private employers in New York State in most instances, has issued a recent decision in a case called McLaren-Macomb that says that just offering a severance agreement to an employee that contains a broad confidentiality and or non-disparagement provision is an unfair labor practice, meaning a violation of the National Labor Relations Act that could subject the employer to penalties. And that's even if the employee doesn't accept the severance offer and never signs the agreement. I'm not going to go into that in too much more detail other than to say that after that decision, the general counsel of the National Labor Relations Board, who's essentially the ultimate prosecutor of National Labor Relations Act violations, issued a memo suggesting that basically any type of confidentiality or non-disparagement provision is likely, in her mind, to be a violation of the National Labor Relations Act, and that it could be applied retroactively, such that she goes so far as to suggest that employers reach out to any employees or past employees who are currently subject to severance agreements that have confidentiality or non-disparagement provisions, and letting them know that the company has no intention of enforcing those provisions. And that by way of saying that if you don't do that, then the NLRB might come along and find you in violation of the National Labor Relations Act, basically regardless of how long ago that severance agreement was entered into. These are pretty drastic and highly questionable positions from the National Labor Relations Board. But if you do have issues and questions about how to deal with this new guidance, you should certainly discuss it with an experienced labor attorney.